to that for about 23 years. I was an employment defense litigator. So the entirety of my legal career for over 2 decades was actually spent representing folks like yourselves. And what I say in mediation is sitting in the defense rooms and working with employers on trying to resolve these disputes. And now as a mediator, I focus almost exclusively on trying to resolve single plaintiff and class and representative actions. The topic for today is emotional distress. And it's a little bit of a provocative title when I say get over it. And that phrase came up because it's often something I hear in the defense room in mediations when the plaintiff presents a number that is correlated to the emotional distress damages and the employer is upset and they say, this person has to get over it. Well, we titled it this because in my estimation, emotional distress damages are probably one of the biggest blind spots that the defense bar has when it comes to assessing the value of these employment cases. And if you've had an opportunity to look at verdicts in California, particularly in Southern California, but really throughout the state in the last 4 years, there has been a significant shift in not only the probability of success for plaintiffs, but the size of the awards and the allocation of the awards, where in the past, the allocation of these awards often were tied to the economic component. Now it's almost entirely on the non-economic side. And so we'll talk today about why that is and strategies that employers can use in mediation to properly evaluate and push back on these claims. Throughout the course, there's going to be an opportunity for asking questions through the chat function. Please do so. We'll try to get to them really in real time if possible. If not, then at the end of the session as well. All right, so why the change in the last 4 years? Well, there's a couple of reasons. One, since COVID, there has been a renewed emphasis on mental health and an awareness, I should say, to the challenges that emotional injuries can pose for individuals. And you see it not only in commercials, and I saw one recently watching a game the other day where there were a number of athletes were talking about the importance of taking care of your mental health, which is just as significant as taking care of your physical health. There has been at least this recognition that anxiety, depression, these things are real, feelings of isolation, and that they do have an impact on your life. And it is something that you would think, well, that's obvious. Haven't people always thought that? But the way that these verdicts are laying out and what juries are saying post-verdict to the attorneys is that there is much more of a legitimizing of emotional injury in the context of adverse employment actions. And so you're seeing the plaintiff's bar has gotten hip to this and has then started to focus almost exclusively on those non-economic injuries. And so what you're seeing, and you may have seen this in some of the cases that you are working on, is a voluntary waiver of economic damages, or certainly at a minimum, a renewed emphasis on the economic damages analysis. And, I saw this actually as I'm preparing for mediation tomorrow. I was reviewing the parties' briefs, and in the plaintiff's mediation statement, they spent about 2.5 pages talking about the emotional injury and what they expected to present at the mediation. And on the defense brief, the employer, I believe it was 1 sentence was spent on the emotional injury. And that's okay. I'm not being critical of the 1 sentence, but you can see where there is a disconnect in terms of how plaintiff's bar and defense bar are approaching the emotional distress issue. And the plaintiff side is saying, we're not worried about the fact that our client was minimum wage and was only out of work 6 months and therefore has a mid 5 figures or low 5 figures economic damages loss. They're focusing on the emotional impact of it. And the reason why they're waiving economic damages or minimizing those is because they don't want to have a jury try to connect the amount of the non-economic injury to the economic injury. In other words, they don't want the defense to argue that the emotional distress damages have to be somewhat anchored by the economic loss. They can't be more than 5x or 4x the economic award. They want to take that out of play altogether so that they can just argue broadly, assuming they establish liability, what would this injury, how should it be valued? How did this really impact their client, and what should a jury, as a reasonable person, award their client? In this last part of access to mental health, we'll talk about this a little bit. One of the arguments I often hear in mediation from the employer is the person didn't treat. They didn't see their therapist, so this emotional injury isn't as significant as what's being alleged. Now, that may ultimately be true, but the fact of the matter is that, and I hear this in the plaintiff's room, most people don't have a therapist or a psychiatrist or a psychologist on speed dial. That's the quip that I get in response. In other words, that access to mental health, while it's becoming more prevalent and more available through employer EAP programs and whatnot, is still something that is considered almost a rich person's problem. That it is expensive, and that it is something, especially in a wrongful termination context, the plaintiff isn't able to immediately afford anyway, given the fact that they've lost their job. And I've seen this recently in testimony where defense counsel presented testimony that said, you haven't treated for this, you haven't treated for that, and you haven't treated for that. And then they stopped. And then plaintiff's counsel got up and just asked one question. They said, well, why haven't you treated? And of course, the response is because I lost my job unfairly, and my family was devastated, and I couldn't get out of bed for 6 weeks, and so on and so forth. And the jury was paying careful attention to that. So the access to mental health is still a primary issue that we talk about in these mediations. So understanding emotional distress, given how big of a component it is in these cases and what we're talking about in mediation, and even if we get to trial, you would think that there is a very specific, clear-cut definition of what emotional damages are. Well, surprise, surprise, there is not. If you look at the jury instructions, and if you look at 3905A of the California jury instructions, the cases as we refer to them, a jury, if it gets that far, is going to be instructed as follows. No fixed standard exists for deciding the amount of these non-economic damages. You must use your judgment to decide a reasonable amount based on the evidence and your common sense. That is the standard that a jury uses in trying to determine what is the value of an emotional injury. So you can imagine the vast sandbox, if you will, that plaintiff's counsel has to try to craft a narrative that appeals to this common sense and reasonable judgment that those jurors have with respect to emotional injury. Now, if you try to dig deeper and try to get more specific definitions in the use notes of these instructions, what you'll see is what's outlined here, which is on these legal definition and parameters. General pain and suffering, fright, nervousness, grief, anxiety, embarrassment is what I often hear, anxiety. And one key component that I'm seeing more and more of, and that is if you look at the second under emotional distress components, the last part where it says in the impaired enjoyment of life. So I'll pose that question to you. What does that mean? Impaired enjoyment of life. How is that to be defined? Well, you can imagine that what plaintiffs are arguing is that whatever that adverse employment action was, whatever that harassment was that they're alleging to have occurred, impacted their ability to enjoy various aspects of their life. And you're seeing the argument in mediation or in front of a jury about what that looks like, whether it's from a relationship with their children, relationship with their spouse. I recently saw in a case the arguments about not being able to participate in some of the club sports that they previously did because they just don't have the energy. They're lethargic as a result of the emotional injury that they sustained. Now, whether or not these are ultimately arguments that carry the day, it is important to be aware that these are arguments that are being made. And in these cases where you see these significant awards being issued, these are the arguments that a jury is accepting as evidence of emotional distress. So when you see these items come up or be alleged either in the complaint or when they come up in the context of a demand letter and you're contemplating whether to go to mediation, these are issues that you want to focus on either yourself or with defense counsel on really trying to get your arms around so that you have the ammunition to really kind of push back on this, or so that you can properly evaluate what the true value of this case may ultimately be if it were to not resolve at mediation. So with factors that influence the valuation, with this slide, it's really the factors that perhaps a judge may look at evaluating the award through a potential remitter or reduction of the award, if that's what defense counsel is asking as part of a post-trial motion. And what courts look at when they're trying to evaluate whether or not a jury properly calculated those non-economic damages, they're looking at the intensity and the frequency and the impact. And so what does that mean? Well, it often is related to the intensity and frequency and impact of the conduct. And I want to emphasize that because when jurors are often looking at these emotional distress arguments, they are focusing on the conduct more than they are of the actual injury itself. And they are extrapolating from that conduct what that injury may look like. And that's an important distinction. I think when people are focused on treatment as the only aspect, and it has to be an argument that employers make, but when they're focusing on the treatment or lack thereof as evidence of no impact, they're talking over what plaintiff's counsel is arguing to the jury, which is that, let's say in a harassment case, where they're going to be focusing the jury on the amount of conduct that they claim their client was exposed to, the frequency of it, and the severity of it. And then they're going to tie that to the jury at the end and say, how would this impact you, essentially, is the argument. And so I think it's important when evaluating these cases going into mediation that you also are looking at the conduct and saying, if this actually did occur, how does this, if at all, change the potential valuation of the emotional distress claim? It's not going to be necessarily tied or connected to a multiplier of the economic loss, and it's not necessarily going to be tied to the number of times the plaintiff treats for that alleged emotional distress. It's often going to be correlated with the conduct itself. Certainly, medical and financial records are really fertile ground for evaluating the extent of the emotional distress, but we'll talk about in a moment, I think, where the real true value is for you all in evaluating those records. I put financial records in there because this is another part which really connected to that impairment of life aspect of these awards, and that is, I will often hear as part of an emotional distress argument that the reason that someone hasn't been able to find a job is that they just haven't been able to, either they're concerned about returning to that same industry as a result of the conduct that they believe they experienced. They're concerned with working in that same type of environment as a result of the emotional distress that they experienced at their prior job, or they're concerned about their mental well-being and their ability to show up at interviews and apply for jobs and put themselves out there. And so financial records actually can be quite valuable in really evaluating if that in fact is the case, if they have experienced some other reduction in their financial needs as a result of this alleged emotional distress. And then courts will often look at previous emotional distress awards. Now, jurors aren't going to look at that. They're not going to have access to that if it gets that far. But you will see, or I will certainly, in mediation briefs, I will see awards that plaintiffs will include in their brief of other cases in which significant emotional distress award damages have been issued. Now, no two cases are exactly alike. No two jurisdictions are exactly alike. And so it's not often an apples to apples assessment. But when you see cases where an argument is that because someone is currently employed, there is no economic loss, or at least it's minimal, and you see a list of cases, and there have been several recently with significant emotional distress awards where there were no underlying economic damages and the person was currently employed, those are something that you, in terms of assessing the value of the case, at least want to be aware of and know that that's a possible outcome if everything went completely south, particularly if the facts may be somewhat similar. If it's a large institutional client, long-term employee, good employment history or record, one infraction that understandably led to termination, but they may try to argue that based on those other factors, the long-term nature of the employment, their good personnel records prior to the infraction, that if argued in a certain way in front of a certain jury, could generate a sizable award. So let's talk about some of the common mistakes that I see in assessing emotional stress. And we hit on a few of these already, and I'd be curious to get your thoughts as well when we get to that point of questions. But as I mentioned, tying emotional distress to economic loss. I will say in almost every mediation that I do, I will hear in the defense room, um, the emotional distress damages cannot be that high because so and so was a minimum wage earner. And so, a multiplier of 5 or 10x off of a $20,000 to $33,000 a year worker only puts a max exposure at under $200,000 soaking wet. And that will be the argument. But again, these awards are not tied to economic damages. A lot of these cases, the plaintiffs are waiving those as it gets closer to trial, especially if they're a low earner. And there is this, in talking with plaintiffs' counsel about why that is, they have recognized that it's often more persuasive to a jury to be able to argue to them that their client has limited resources, is a lower earner, and as a result, this emotional injury has had an even greater or outsized impact on them. In other words, they have seen that with higher earners as plaintiffs, that sometimes there's a presumption that if you make more money, then you must naturally be happier and don't have or suffer or experience the same level of emotional distress. Now, that's hasn't been obviously scientifically proven, not necessarily true at all, but you've seen whether through recent case with the Tesla case a couple of years ago and some others recently, where in fact that was the strategy, was focusing on the fact that they were a low earner, and that the impact actually was more significant as a result of the fact that they didn't also have the resources to properly address the emotional distress for the future non-economic loss. So, and again, as we talked about earlier, if you look at the jury instructions, there is no formula that is provided to the jurors that suggests that emotional injuries have to be connected to or tethered or anchored to the economic loss. The other aspect that I see come up is the cultural and community considerations. So there are a number of cultures, number of communities where mental health is still somewhat taboo. In other words, the first outlet to address emotional injuries is not necessarily going to, again, a medical provider, but it might be more faith-based. It might be more community-based. It might be more family-based. And jurors are receptive to that. And so the fact that someone says, I decided instead of going to a therapist because I couldn't afford it because I lost my insurance, I instead went to church and prayed with my community and talked to my pastor or whoever it is, those arguments carry some weight with the jury and certainly can be at least evidence that they can consider in whether or not this person actually experienced emotional distress. So don't be dismissive of those potential arguments or considerations, because they are ones that could, under the right circumstances, be made in front of a jury. We've talked about the lack of treatment as well, that there is no fixed standard that says you must have treated for that emotional distress in order to actually experience it. Plaintiff's testimony in and of itself can be enough evidence for a jury to latch onto. And as we spoke about earlier, often the jury is focusing on the conduct itself. If they believe it occurred, it's not hard for them to imagine that there was a non-economic injury connected to it. In other words, I'll hear the argument from employers that, well, even if we lose on the merits, we don't believe a jury is going to award economic or non-economic damages to this particular plaintiff because they didn't treat or they didn't talk much about it in their deposition. And the response to that often is, if a jury gets to that point where they do determine that something happened that was unlawful, it is not a stretch for them to believe that unlawful conduct, once determined, also creates an emotional injury. So again, these are items that at least you want to be aware of and thinking about when you're going into mediation, so that when perhaps you're preparing your statement, or preparing your arguments or what you want to present to me, it isn't necessarily just a one sentence thing because the other side is focusing heavily on these aspects of it. And it's going to be a big part of the discussion in that room that they're going to want to have with you through me at that mediation. And then I'm going to say this with the other common mistake. And as I mentioned to you all earlier, I was a defense employment litigator for over 2 decades. So I may have been guilty of this as well. It's the late analysis of the emotional distress. As you all probably know, typically in the life cycle of these cases, the emotional distress component is usually one of the last areas of discovery in a case. And a lot of that is because of the cost. I think there may be some other factors at play. Maybe it's something about leaning into the emotional injury. Plaintiff's counsel often makes it difficult to get medical records earlier on in the case. There's motions to quash, all of that. Usually in depositions, it's one of the last topics covered. So if I'm mediating a case and one day of the deposition has been taken, the emotional stress component hasn't been discussed yet. But the problem is this, with emotional distress becoming a bigger and bigger component of the potential damages and certainly the argument in truly assessing an accurate value of the case, if that analysis isn't being done up front, you are at somewhat of a disadvantage going into the mediation and trying to address it there. And so there are ways in which, and this really is an argument for both the plaintiff's bar and defense bar, but there are ways in which you can try to get in front of these issues. For example, if to the extent they exist, getting these medical records right away through subpoenas. There's no temporal reason why it has to occur later. Making sure that that testimony has been locked in a deposition to the extent you need to have it locked in. Making sure that those responses to written discovery have been obtained so that you can start to evaluate, is this really going to be a component of the negotiation or the potential exposure in the case? But certainly the waiting until the very end to assess this value of something that's going to be such a large component throughout, I think puts you at a little bit of a disadvantage in terms of really understanding and getting your arms around these cases. And I think that's part of why we've seen some real surprise reactions from defense counsel when some of these verdicts come out. And they'll say credibly, I didn't see it coming. And they'll look honestly at themselves and say, maybe we should have looked at some of these issues a little bit earlier in the case and really tried to see if it would have the impact that it ultimately did. So I won't go into great detail with the verdicts, but I will point you to access to these verdicts. I think in at least being aware of them, if you're working through outside counsel, making sure outside counsel is making you aware of them is important. Just to have at your fingertips so you really know and you can report to everyone you need to report to at least what the potential outcomes could look like. I'm not saying that it changes whether or not in your particular case the plaintiff is going to succeed on the merits. It's more at least understanding truly what the full exposure analysis could possibly look like. And so if you just looked up, for example, top 23 employment verdicts in California, you will quickly see the list of the cases of reported verdicts that have come in. They'll have a breakdown of the non-economic damages to economic damages. They often will have, in fact, the experts that were used in each case as well. And obviously they'll have the venue and jurisdiction that the case took place. They'll have the length of the trial often attached to that. It's easy information at your fingertips that I think can be helpful in putting together a full picture of what all the potential outcomes could look like. Again, it doesn't mean that you lose on the case by any stretch, nor does it mean that whatever award was given in San Bernardino is going to be the award that you're going to receive in San Diego if you're hit. But it does provide a fuller picture of what is potentially possible if your facts are in any way analogous to the ones in those particular cases. So I think it's important there also, when looking at these decisions, you'll get a sense of how many of these cases I mentioned where there's experts. You'll get a sense as to how many cases there are no experts. There was a verdict last week where, and it was an employment case, a little bit of an unusual one, but the award was roughly 100,000 in economic loss for this particular individual. And the jury came back and awarded about, close to $1 million in emotional distress damages. And defense counsel, prior to the trial, didn't believe that there would be any emotional distress damages whatsoever, and was adamant about that. And it was impacting their discussion of resolving the case. And then, much to the surprise of the defendant, the jury also found that there was malice, oppression, or fraud. And so there was a second phase of the trial, and I believe it was last Thursday, the jury here in San Diego came back with $20 million in punitive damages. So $20 million in punitives with about $1 million in emotional distress on a case where there were no future economic damages sought, and the past economic damages were $100,000. Now, obviously, the devil's in the details and going back through the facts, but the blind spot in leading up to that case was recognizing how that conduct that at least was being alleged, if proven, could inflame the jury, and how connected that analysis of whether or not there's emotional distress is also to whether or not there's potentially punitive damages, because it often is all pulled from the same well. So with overall strategies, let's talk about ways in which you can get focused on these particular issues ahead of time so that you can push back on them. Obviously, to the extent that the plaintiff's deposition has already taken place, and it doesn't have to for mediation to be successful, but to the extent that you have that testimony, make sure that the questions have been asked about treatment, about the extent of the emotional distress. It is something that can be really important, even in a mediation setting, especially if I hear arguments about the extreme nature of it, but you have testimony that perhaps suggests something different from a negotiating standpoint. That can have an impact on our discussion. Also, on a credibility standpoint, it can have an impact on discussion. And with treatment options, we talked about whether or not someone treats or not is not dispositive of whether or not they've experienced emotional distress. But certainly, it's still an area that you want to go into. And if they haven't treated, like we talked about earlier, try to find out, well, what are those reasons? As I said in the example of the depositions where someone may ask those questions but didn't ask the why. Ask the why questions of why someone hasn't treated. Maybe there are cultural arguments at play. Maybe there are community or other faith-based arguments at play. Maybe there are financial reasons why that person hasn't treated that. You at least want to know what those arguments are so that you'll have responses to them going forward. And as I mentioned earlier, medical records are key to the extent that they exist. And they're not necessarily key for purposes of establishing, in my opinion, whether or not there was emotional injury. The reason, and I think the most effective way that these records come into play, is from a credibility standpoint. And so I recently had a case where the plaintiff had alleged that as a result of the wrongful conduct and termination, that her relationship with her children had drastically changed. And it was a compelling narrative that the plaintiff was testifying about. But the defense got the medical records, and the medical records actually showed that, and there was a note from the doctor that said, one of the silver linings of the termination is that the individual told me that their relationship with their children has improved dramatically because they've been able to spend more time with them. And that contradiction greatly impacted that person's credibility with respect, not just with respect to the emotional distress, but with respect to the other allegations as well. And it dramatically impacted the value of that case going forward. So those medical records can give you some insight as to the credibility of the testimony itself. And it also can give you a better idea of the chronology. For example, in the medical records, you might get a better understanding as to whether or not someone was treating while the conduct was occurring, as opposed to after. And it can push a little bit on that chronology if it doesn't really line up with the testimony. As part of this, I would also suggest, if you have disability-related cases, Oftentimes there's a workers' comp component to it, and there's a separate track that's occurring with that workers' comp process. But there are often more robust medical records in that file than you would find or receive from the plaintiff in the civil action. And so you'd want to investigate subpoenaing those workers' comp records as well, so that you can see whether or not through a QME or an AME or some other examination, what the true nature is of the emotional injury that may be being sought in the civil action. So this is even if there's a physical injury in the disability case that is the component of the workers' comp case. There often is discussion about emotional injury that also takes place. And so that can be a really important, it's surprising how many times it comes up for the first time in a mediation where I'll ask the question, is there also a companion workers' comp case? And the response will be, yeah, there is, but we're not dealing with that right now. That's handled through insurance and separate. It's all true. But the next question is, well, has the plaintiff been deposed in that action? And it's silence then across the table. And they later learned that, yes, the plaintiff actually was deposed in that action. Not even the plaintiff's lawyer in the civil action is aware of that. And they've already sat for several examinations where emotional injury was in fact discussed. And you later find out that in the context of the workers' comp case, that the emotional injury that is attached to the workers' comp case is described in that proceeding as the very same emotional injury experienced in the civil action. And so while it may not fully knock out that claim in your civil action, it often is an incredibly impactful argument that I see used or employed at mediation to at least push back on the plaintiff to say, it's possible, especially if that workers' comp case has resolved and there's an addendum to the compromise and releasing all claims, including the emotional injury claim, where potentially that's at risk through a motion in limine or otherwise. So another just perhaps long-winded example of why these medical records, I think, can be so important to take a look at and at least have some understanding of what's in there before you get into mediation, in anticipation of the arguments that you're likely going to hear about the damages associated with them. We talk about a few other considerations that I want you all to be aware of. Oftentimes, I will hear in mediation that we've taken a look at the records and the plaintiff has a horrible history of past abuse, trauma, alcoholism, and as a result, we're going to be able to show that any emotional injury that they experience as a result of being terminated really is connected to their past trauma that we had no involvement with and should not be held liable for. And so it's presented often as a source of strength, and I get it. But I want to make everyone aware that there's a very powerful jury instruction that in cases like this are often given, and it's called the unusually susceptible instruction. It's KC 3928. And essentially, the instruction itself states that simply because a plaintiff is potentially more susceptible to injury than a normally healthy person as a result of their any prior mental health issues or trauma, it really doesn't impact whether or not they are damaged by the current contact. In other words, you take your plaintiff as you find them. And so this instruction basically allows a jury to say that even if the plaintiff in the current civil case is experiencing a greater emotional injury because of past trauma, that doesn't alleviate the liability or the damages for the current employer. And so that is something that I often find employers aren't aware of. And often plaintiff's counsel isn't aware of this as well. But it is something that is significant in that, at least as part of the evaluation, you need to be aware of. It also connects to this idea of alternative stressors. And I understand the argument, I've made it myself many times, where you look in the file or the medical records or the testimony, and you see evidence that the plaintiff has had other areas of significant stress while they were employed that you want to argue or more correlate more to the emotional injury, if you will, than the actual termination or harassment or whatever the wrongful conduct that's alleged. And I understand these arguments, but I always say be very careful with how you want to craft those arguments, because as you might imagine, with good trial lawyers, what I'll hear is that they'll craft a very powerful survivor narrative that's connected to the emotional stress, especially if it's connected to past trauma. And the way it usually unfolds is this: the defense counsel will argue that they'll say, we have these medical records. They show that the plaintiff was molested by a relative at a young age, that they suffered from alcoholism, that they struggled through domestic abuse even before coming to us. And these are all injuries that we're not responsible for, but we think these are really the emotional injury that might show up on a later test scores. But the way the narrative gets turned into by plaintiff's counsel is, this is a survivor. This is someone who's had horrible things happen to them throughout the course of their life. And yet they were still performing their job satisfactorily until this incident occurred. And then everything fell apart. And it was the last straw. And you can see through that argument, whether or not it's compelling or not, sometimes jurors do look at that and say, you know what, we all can relate to past things that have happened in our life. But certainly, in fact, they may even argue that this person experienced all these horrible things and they still kept going and they still kept moving forward and having a family and being a good parent and doing these things. So the fact that right now they're really struggling, well, gosh, something now must have really happened in order to push this person over the edge. So you want to look at those things through the full lens of what the overall narrative might look like. And then we talked about this earlier, this correlation with punitive damages. If you look at a lot of the awards that have come down, one thing that I remind plaintiffs' counsel often of is these awards are often achieved by actually a small handful of lawyers that are parachuting into the cases later in the life cycle of the case to try the case, because they are good at connecting the dots and telling these stories. And what they often tell me privately in mediation is they say, you know, employers aren't understanding the connection when punitive damages are available. Obviously, some entities they're not. Some cases maybe don't warrant them. But what they say is that employers aren't seeing the connection between if we as plaintiffs' counsel are arguing that this conduct was so horrible, so terrible, that it was going to create this massive emotional injury, and a jury agrees with us that there was this conduct that occurred and it did cause this injury, it's very easy to apply that same argument to punitive damages. In fact, if they feel like if they've gotten there, they've already established a high likelihood of establishing malice, oppression, or fraud. And if so, they believe that they're going to get a pretty significant component of punitive damages. And so what I often look at is, when I had my defense hat on, is the argument that I'm going to see for the emotional distress damages that I need to craft a defense for is often the same that I need to craft for punitive damages. And if there is a potential exposure on those emotional distress damages, particularly if the conduct alleged is pretty egregious, then that corresponding exposure likely applies to punitive damages as well. So again, it's something that in crafting this overall, let's say a pre-mediation or pre-trial analysis, you at least want to be able to have your arms around and be able to address, because without at least having your arms around it, you really can't craft a defense. And too often I will see pre-mediation reports from the defense that essentially say about emotional distress, we'll be in a better position to assess the viability of an emotional distress claim when and if we take plaintiff's deposition. Or I'll see under the punitive damages analysis, we don't believe a case like this warrants punitive damages, so we're not going to place any value on them whatsoever. I get it as an argument, but I don't necessarily get it as a strategy. because I think you need to at least acknowledge, in order to have an effective defense, you have to not acknowledge the possibility of those things occurring. So it doesn't mean they are, doesn't mean that you have to actually place significant value on it, but it at least allows you to have a defense that you may then present through me to the other side that can push back on those particular issues. And then this other aspect of it that I think actually applies to everybody is lean in to emotional distress aspects in a mediation, because it actually can be really beneficial in terms of achieving a favorable resolution for the employer. And what I mean by that is that if there's a willingness to at least acknowledge the possibility of emotional injury, sometimes that in and of itself, without even placing some value on it, is enough to move the needle in the other room to resolve the case. In some ways that this manifests itself is a willingness to hear the plaintiff out through the mediator on a particular issue. Sometimes the plaintiff wants to give an impact statement, and it can be really uncomfortable. I'm not going to lie to you. It can be uncomfortable as the employer to sit through and listen to, but it can have a huge impact on the ability to move forward and resolve the case. Often a big part of what I do as a mediator, and I'm sure all mediators do this, is when I'm spending time in the plaintiff's room, it's actually providing that cathartic aspect for them to say whatever they need to say to me and vent. But sometimes it's even more effective when they have an opportunity to do that in some form or fashion, either directly to the employer or at least allowing me to present those positions just for the employer's consideration. And then we can move forward and actually try to resolve the case. And I know it seems common sense, and you would think that that would happen, of course, all the time, but understandably, leaning into that, it can feel uncomfortable, particularly early in the mediation when everyone's back's a little up when we get started. Dealing with emotional issues, it's not something that folks say, we're going to mediation so we can take the emotion out of it and try to be pragmatic. But the fact of the matter is these cases are emotional for everybody. I know that representing employers for 20 years, my clients were emotional as well, and often would need some emotional outlet through the mediator to vent about how the lawsuit has impacted their life, and being accused of the things that they're being accused of have impacted them. And so leaning into the fact that there is going to be emotion naturally with an employment dispute that is connected to getting this resolved can serve as a catalyst for resolution. So these are things I think that going in, and I'm mindful of, again, this mediation statement that I received that had one sentence applied to it versus the 2 pages, that there's going to be a lot of discussion needed in the defense room about at least what the plaintiff is trying to get across on the emotional distress that you would like to see at least analyzed and dealt with ahead of time. So that we're talking apples to apples and not talking about information that potentially is perceived as new in the other room. Briefly on expert involvement, many of you probably know that, and this is part of the reason why emotional distress damages are often only looked at towards the end of the case. Typically in an employment case, as you know, as the case gets closer to trial and parties are contemplating experts, the defense will designate an expert to conduct an independent medical exam or an IME of the plaintiff. And then in getting ready for that exam, that expert will then review records from any other prior medical providers or treaters, meet with the plaintiff, go through a number of tests with that plaintiff, and then issue a report. Plaintiff's counsel will then often retain an expert who will review that report and offer opinions, and you'll have these dueling opinions. An IME certainly can be a terrific way of really getting all of that information together in one form and presenting it through an expert who is going to give testimony that's going to be favorable for one side, whoever's hiring him or her. The problem is that it's often at the end of the case where this happens because it's expensive. So really getting your arms around potential exposure and issues, if you're mediating a case earlier in a very emotionally driven matter, you're not going to have that ammunition then. And so Sometimes doing that sooner rather than later can be beneficial, particularly if you believe that IME is going to have an impact on the valuation of the case. And sometimes it does, and sometimes that is often why defense counsel wants to do it. Just one area of caution with that, in a case where the conduct may be so egregious that if proved, it's a no-brainer that there'd be an emotional injury. Now you're disputing whether it occurred, maybe he said, she said situation, so you're not conceding anything on the merits, but you recognize that if the plaintiff is successful on proving this case, there will be an emotional injury that a jury will find. Having an IME and having your own expert confirm that can be a challenge, and actually can backfire, because then, as you might imagine, plaintiff's counsel will testify that even defendant's own expert acknowledged they can't opine on the credibility of the witnesses, but they acknowledged that if this conduct did in fact occur, which you, the jury, we believe will decide that it did, then it would have created the significant emotional injury that continues through this day and will continue out to the future. And by relying on your expert for that, you being the defense, that can create an even more sizable award and make it more difficult on a remitter when a judge is looking at this and the judge is saying, gosh, defense counsel's own expert also confirmed that this could be significant. So I'm not sure that I should reduce the award by any sizable amount. So it's just something that you want to be mindful of, and not just say we're going to do an IME. You really want to give it some thought as to whether or not it's going to truly advance your narrative of the emotional distress case, as opposed to just being something that is thrown out there as you're going to have to be, you plaintiff are going to have to go through this invasive process of an IME, which is often how I hear it presented. And while that's true, that's not the end of the story. With the treating medical providers, because I see often a focus on the IME as the next step in evaluating the emotional distress, I'll ask if the treaters have been deposed. And often the answer is no. We got the records, but we didn't depose them. And I would just say, in looking at cases where the emotional distress component could be big, having those depositions taken could be really valuable. And they're often not very long depositions. But again, what you're looking for often is just either confirmation or corroboration or lack thereof, or some break in the credibility of the narrative between what was provided in deposition testimony and in what you're now seeing through that witness's own doctor. So don't fully discount that, or if you're working through outside counsel, don't let outside counsel fully discount that either. They aren't really challenging depositions to take, and they often are not very long or very expensive, and they can sometimes prove helpful because really you're just trying to confirm what's there and what's not there. An example of how it can work effectively is if a treater has a particular diagnosis, but they didn't consider a number of different things that the plaintiff testified about, and you present that information to that witness, and the witness, and then at the end say, had you been aware of these other aspects as I've represented, would that have changed your diagnosis? And sometimes they say yes, and that has a huge impact on everything. And you don't always want to wait to trial to do that, especially if you want to use that information to create a more reasonable settlement value for your case. Lastly, let's talk about just a few of these mediation issues, and we've talked a little bit about this, about how it comes up, but obviously timing is crucial in mediation, particularly talking about emotional distress damages. If it's going to be a sizable part of the case, you can still do mediation early, and sometimes it's even better to do it early, even without some of these records. But you might want to agree, and plaintiff's counsel often will agree as well, to some informal exchange about information regarding treatment or anything else that will help with the analysis. Also, sometimes earlier is better because as the case goes on in an emotionally driven complaint, those emotions only heighten. They don't reduce. The system is adversarial, as we all know, and acrimonious, and that can sometimes get make it more difficult to resolve later on an emotional basis. So sometimes earlier is better, but really ask yourself, is the time right? Because it may be that you feel that a deposition has to take place in order for an effective mediation to occur. Choosing the right mediator, anyone who mediates these cases and focuses on employment cases should be well equipped to handle the emotional aspects of these cases. But there may be some that that's not their strong suit, that they are much more on the objective in terms of just focusing almost on the numbers aspect of it, which is fine. But if you have an emotionally driven case, you're going to want to work with a mediator that can address the emotions in your room, because you may have a client that also feels very strongly about it, or you may be that client that feels very strongly about the allegations being alleged. Or you may need a mediator that's going to be able to speak to the plaintiff on that emotional level in order to, again, provide that cathartic background so that you can move past that and get to a pragmatic, reasonable settlement. So give some thought, and if you're working with counsel, have outside counsel give some thought as to who they're using for that particular case, if that's going to really be a big component of it. The right audience is also important. If you have a case involving harassment, and does it make sense to have the alleged harasser present at that mediation with you? It may not. And so you want to give some thought as to whether or not it makes sense to have certain people that are going to be hearing the particular arguments in the other room, given the emotional intensity of the case. I always talk about preparing the client. And if you are attending this and you are the client, well, it's also preparing your internal folks, right? And your internal business groups in terms of understanding what it is that they're going to likely be hearing at the mediation. And I'd also want to understand, if I'm in your position and I'm working with outside counsel, I'd want outside counsel to prepare me for what am I going to be walking into in terms of the arguments that I'm going to hear. And so, especially if they're going to be emotionally driven, because then I'm going to have a lot of questions about what's the basis for this, and I want to be prepared. Or I may want to have someone else in attendance as well, given what to push back on what I'm anticipating hearing. So it all goes down to no one likes surprises on the defense side, and so you want to make sure that you're well prepared, or that you've prepared others for what you're likely going to hear. And then, as I discussed, all this information that you've compiled or in the process of compiling ahead of time, prepare the mediator with it as well. It is incredibly helpful. We review the briefs that we receive. The information can be extremely valuable to get to us ahead of time, especially if either you have another representative with you at the mediation, where some of what we're going to be discussing is going to be highly, highly sensitive. Prepare the mediator so that the mediator knows how to respond and address the issue appropriately. Or there may be information that you believe is emotionally inflammatory but relevant to the case, and you want to talk to the mediator about how to best present that and when to present it in order to really maximize the potential of reasonably resolving the case. So really working with the mediator and collaborating with your mediator on that, it can be extremely, extremely helpful. And really in that vein, if you have a good comfort level with that mediator, asking the mediator for what is their impression of some of the emotionally driven arguments that they're listening to. As a neutral, you're gonna hear an objective, unbiased response to it. And sometimes that response is, this person really persuasive. And there are times when I've said, I understand what they're trying to do in that room. I'm not sure that their client is as persuasive on that front. Doesn't mean, that you're out of the woods, but some of those arguments, fall a little flat, especially in light of everything you've provided in response to it. So really bouncing those ideas off of your neutral and those thoughts can be really helpful. And the last issue we've talked about, which is really recognizing the risk. I think the biggest thing is just recognizing it. Doesn't mean you are conceding it. Doesn't mean that you are saying that there must be an increased value of 10x because of the emotional distress allegations, but you at least want to recognize what that risk may or may not be. And if, again, for nothing else, it's going to allow you to present the appropriate defenses and arguments at the mediation that I can then use to push back on the other side. Okay, I don't know if there's any questions. We've got a couple minutes. If anyone does have any questions that they'd like to ask me, I appreciate your patience with this and sitting through this with me.
There's a question in the chat for you.
There is a question?
Yeah.
Okay. All right. Let me see. Okay. And so the question is, if a comp claim has not been made, but a psych injury emotional distress is alleged in a civil case, is it possible to compel the emotional damages psych claim be brought in comp due to comp exclusivity? So it's tricky. You almost always allege as in your answer as one of your affirmative defenses, workers' comp exclusivity. But the connection, let's say, for example, the emotional injury is the reaction to harassment, let's say physical harassment, or maybe more in line of a disability case, where they perhaps were injured at work but did not bring a comp claim, but believe that as a result of that injury that they have been emotionally injured. I don't know if it would be that successful to try to compel that under work comp exclusivity, only because part of what the plaintiff's counsel is going to do is they're going to connect it to the reasonable accommodation and interactive process and disability claim arguments as well. And they're going to say they're all intertwined. And so they're going to argue that, yes, there was an injury that the person experienced on the job. They didn't file for workers' comp, but they're nonetheless disabled under the law, and their emotional injury is also tied very much into how the company responded or didn't respond to their request for reasonable accommodation or didn't engage in the interactive process. So I think it's a good argument to at least raise in a mediation. I think, though, ultimately, practically speaking, probably won't be able to push it into that area. Where I've seen parties really try to push that argument is in what I'll say are horseplay cases, where someone claims that, and it's sometimes male-on-male harassment, where the defense is, hey, this wasn't sexually motivated, even though that doesn't have to be the standard, as we all know, but it was just we were playing around, and there was any injury from that kind of interaction or horseplay in the work should be in the realm of workers' comp. But even then, it's pretty challenging. But I like the creativity with that argument. I think the last question I see here is the failure to mitigate any real defense anymore? It's a fair point. The failure to mitigate often is only applied, practically speaking, on the economic, the ability to find or not find another job. You will make the argument that, and often the employer has that burden to show, if there's a failure to mitigate, that you should have done this and that you had an obligation to seek out help. I guess my point is that what a jury is saying is that treatment is not necessarily the only help available, that there can be less formal ways that carry the same amount of weight, and that there are other financial reasons and that are compelling to a jury as to why someone may not be able to fully mitigate by going to a therapist and getting a psychologist and getting a psychiatrist to prescribe medication, doing all of those things as a result of losing their job. I don't think a jury, at least what these verdicts are showing, are necessarily going to hold that fully against them. It could have an impact on future non-economic loss, because the plaintiff still has to show that this, for the future non-economic, that this is going to be, that this injury is going to continue for some period of time. But their own testimony could, under the right circumstances, be sufficient enough for a jury to say, you know what, we're gonna find for the plaintiff on this issue. And then again, it's no clear standard for what those amounts should be. And plaintiff is typically going to ask for seven figures at a minimum, somewhere in that seven figures for those damages. The typical number I see is 3 million is what they'll throw out there, knowing they're not going to quite get that, but giving them enough room to get something else that can be compelling. Any other questions? Okay, well then I will, I want to be respectful of your time. Thank you for attending. If anyone does have questions, I can always be reached at jandrews@signatureresolution.com. Feel free to reach out to me anytime. I love talking about these issues. And I'd love to hear your thoughts further to the extent you'd like to connect. So appreciate your time and take care.